Good morning, everyone. Thank you for being here. This is the technical hearing for the 2026 TAP-R reconciliation filing before the Water, Sewer, and Stormwater Rate Board. I'm Catherine Sophie, the hearing officer for this proceeding. With me is Sonny Popowski, who is chairman of the Rate Board. We also have Ryan McSherry, who's the attorney for the Rate Board, and Khadijah George. She is the Rate Board's office manager. There is a court reporter here who will provide a transcript for this hearing, so please speak clearly and slowly. The transcript will be posted immediately to the Rate Board's website, and I believe we've got a 3-day turnaround. And at this point, I'd like to ask the participants to introduce themselves, starting with the Water Department.
Thank you. Andre Desant for Philadelphia Water Department. And with me is Renardo Hicks and Brooke Darlington. For us, unless there's someone online that one of our general counsel, and I'm now Carl also is here. Carl Schultz from Eckert Siemens.
Public Advocate.
Good morning. Thank you, Your Honor. Robert Ballinger here for the Public Advocate, and I am joined by Vic Patel virtually at this hearing this morning.
Lance Haver.
And the Philadelphia Large Users Group.
Good morning, Your Honor. This is Adelu Bakare here virtually for the Philadelphia Large Users Group. My colleague, Victoria Geddes, is also going to participate virtually. We may not both be on for all of the hearing, but at least one of us will be on for all of the hearing.
Okay, thank you. Well, before we get to the witnesses, are there any preliminary matters?
I believe we have any preliminary matters except to inform the hearing officer, at least by agreement, that we will stipulate as to the authenticity of the testimony we're presenting for the Philadelphia Water Department this morning.
And likewise, obviously the public advocate will stipulate to the authenticity of the department's testimony in exchange for the reciprocal stipulation.
All right, well, with that, we can begin.
Actually, here also, may I ask one question about I'm sorry. It's been prior practice that in addition to testimony, all the discovery is considered part of the record, whether actually formally introduced at the hearing or not. Is that still going to be the case this year?
That is the case.
Let the record reflect. I'm sorry.
Mr. Haver.
I don't know that he was finished.
I'm finished. Thank you.
Let the record reflect. I make no such stipulation. I do not agree to that stipulation. I do not agree to the authenticity of either of the parties that have said that they have a secret agreement between themselves. Thank you.
All right, the Water Department.
This morning, we're prepared to proceed with a panel of witnesses from Black & Veatch and Reftelis financial consultants. And on the panel for Reftelis, or RFC, is Henrietta Locklear and Jennifer Travantis. On the panel for Black & Veatch is Brian Merritt and David Yacht. We are prepared to proffer their testimony. Because we have no corrections or revisions, we have stipulated to the fact that we don't have to go through that step in the proceeding. And that was the extent of our agreement. Thank you.
Morning. I'd like to jump in to some cross here. I'd like to ask the witnesses to please have your rebuttal testimony as well as the public advocate hearing exhibit number one and only in front of you, please. And I just would ask to to have this marked and entered onto the record as the Public Advocate Hearing Exhibit 1. And I will acknowledge that I dated this as of yesterday because that's when I sent it. It should be dated as of today. But with that small adjustment, I'd like to start with the rebuttal statement on page 4. And in lines 13 and 14, lines 10 to 13, you discuss production data regarding TAP participation, right? I want to make sure we're in the same place. Can you confirm?
Just 1 second, please.
This is the rebuttal statement, page 4, lines 10 to 13.
Yes,
And you have a footnote in the rebuttal testimony that says production data is subject to restatement, correct?
correct.
Based on past experience, you would expect that if you updated your production data, that participation levels for the months you discuss here would change, wouldn't you?
If we updated the production data,
Yes.
meaning what?
The participation level, you would reflect different participation levels than what you have in the production data you've supplied on the record. The numbers would change, wouldn't they?
Yes,
And since we've talked about this before, I just want to confirm my recollection. Isn't it true that the changes are typically higher in more recent months and lower in older months when you rerun production data?
Objection. This is, if it's a factual question, you would relate to the exact exhibit that we're referring to, which is either PWD 7 or 5, and it will change or not, depending upon the circumstances presented.
We've covered this in the past. I just want to make sure that I understand how your production data works. It typically reflects larger changes in more recent months. Isn't that factually correct?
Objection calls for speculation.
If you can answer the question, you may go ahead and answer the question.
okay. When data are rerun at a later time on production, the differences between more recent months are greater than differences in earlier months, generally speaking.
Thank you. Continuing on this page in lines 13 to 14 of page 4 of the rebuttal, you go on to say the observed growth contradicts the advocate's assumption of no changes in average participation. What average participation are you referring to?
The public advocate's witnesses assumption of no growth in participation is what that refers to.
And let's go ahead and turn to the first page of the public advocate's hearing exhibit. Tell me when you're there. It's numbered 1 on the bottom. It is actually the second page of the PDF if you're looking at the PDF.
I'm there.
Okay. And this is the public advocate's response to PWD interrogatory TAP 1-9. Have you reviewed this response?
Yes, I have.
Did you review it before you filed your rebuttal testimony?
I can't be sure.
Isn't it true that at the time of Mr. Morgan's testimony, his projected average participation level was 2,890 higher than the prior 12-month average?
Just for clarification, the average for what period?
If you review the response, it says, by using the most recent level of enrollment, March 2026, 68,405 for the projected period, Mr. Morgan's testimony and schedules provide for an average participation that is 2,890 TAP participants higher than the most recent 12-month enrollment average, April 2025 through March 2026. Isn't that factually correct?
That is what the statement says.
And isn't that correct based on the model you provided?
If you give me 1 second, please. Okay, I can confirm that that's the correct average for those months. Mr.
Thank
Brown.
you. And just for the record, if the average rate of participation that Mr. Morgan projects occurred, that would in fact reflect growth in the program from the historical average rate of participation, would it not?
He does begin at a higher number than the historic average. That's correct.
And if maintained consistently throughout the projection period, would that not result in a higher average over that projection period than what has been experienced so far?
It is higher than what was in that past period. Therefore it's growth over the past, but it's not growth through the next rate period.
In your rate model, you've projected 0.25% growth in participation in each month of the projection period. Isn't that correct?
That is correct.
And then to derive an average for purposes of the rate model, you calculate the average of each of those months as you've escalated them. Isn't that correct? For purposes of the C factor, you have to use a single number of average participants. Isn't that correct?
Yes,
Okay. So you average your 12 months, each of which escalates slightly by 0.25%.
correct.
Let's turn to page 2 of the Public Advocate hearing exhibit. And this is information taken from the Rate Rider Reconciliation Workbook filed in this proceeding. And it contains the months September, it contains participation level for the months September 2024 through December 2025. And would you accept that that's what this is, subject to check?
Just for clarification, when you say the workbook, is the revised or updated workbook that was provided April 15th?
This is the workbook as it was filed with the advance notice.
Thank you.
I'm asking the witness to just either confirm that that's what this data is and it's where it's taken from, subject to check if you'd like.
Subject to check. Yes, thank you.
Thank you. So if you look at the participation level in November of 2024, you would see that the number of, and this is, I believe, the number of TAP bills issued in the month, declines from the number of TAP bills issued in October of 2024. Isn't that correct?
That's correct.
And the participation level declines again in February of 2025 compared to January of 2025, doesn't it?
It does.
And again in November of 2025, the participation level declines substantially by almost 9,000 participants, doesn't it?
Yes, and as you mentioned, that's the number of participants measured as bills.
As bills issued. I anticipated my next question. So do you believe this reflects a change in TAP participation or a change in TAP billing?
It is a reflection. It is the number of TAP bills, as we've discussed, and it reflects the fact that there are fewer billing days in November. and than there are in the months surrounding it. So there were fewer days, and therefore fewer bills issued in November than in October.
And so if a certain number of bills were deferred or accelerated out of the November billing period, we would expect to see them reflected in the October and December billing periods, wouldn't we?
Generally,
And can you confirm for me that the number of bills issued in September is 300-ish lower than the number of bills issued in October of 2025? 300 and change?
yes.
And then
About,
compared to October, December reflects 700, less than 700, 600 and, I'm not good at doing math on the spot, 660, I think.
I'm sorry, can you say which months again?
Just comparing October
about-
2025 to December. There's a very small increase in the number of bills issued in December compared to October. Isn't that correct?
That's correct. It's 67,155 in October versus 67,815 in December.
Thank you. Let's move on to the next page in the Public Advocate hearing exhibit. This is page 3. And just like to confirm that what is here is PWD's response to Public Advocate Discovery Set 4 number 2, PA-TAP 4-2. Is that correct?
That's correct.
Okay. And just to tie this response into the discussion we just had, this response confirms that IDEA pre-qualification was ongoing during the entire time period that we just referenced in the prior page of the exhibit, September 2024 through December 2025. Isn't that correct?
That is correct.
I'll let Mr. Desant help if this calls for a different witness. I'd like to turn to page 15 of the rebuttal testimony. Lines 12 to 14, please. Are you the right witness to answer a question about this section of the testimony?
Sorry, I'm running behind you a little
It's
bit.
okay. Thank you, Ms. Locklear.
Okay. On page 15, I can still be the witness, I believe.
Thank you. And so I'm looking at lines 12 to 14, and the testimony states the TAP-R methodology agreed to by the public advocate in 2016 is designed to adequately recover TAP program costs, limiting the financial impacts to the department. That's what the testimony states, correct?
That is what it states.
And do you want to correct that statement in any way? I believe it would be the same correction that appeared in the department's public presentation. Isn't it true that when TAP launched, the projected costs of TAP were included in PWD base rates in 2016?
We'll stipulate it's 2018. I'm sorry.
Okay.
That's my fault.
Thank you. So you would agree then that the TAP rider was agreed upon in the 2018 rate case after a period in which the department recovered substantially more than the discounts through the base rate recovery methodology. Isn't that correct?
What I will be willing to answer is that I see on your hearing exhibit, page 5, you provide the rate determination excerpt from 2018 that discusses that agreement.
Let's go to page 5 then. Again, you've anticipated the direction here, which I appreciate. Paragraph A at the top of page 5, do you agree that what was reflected there and was the product of the agreement between PWD and the public advocate was that PWD would use actual data from the first 9 to 10 months of the current period, plus a period of 2 to 3 months of projected data in estimating the 12-month period of TAP revenue loss and surcharge revenues? Isn't that correct, what that states?
Just so we're clear, Mr. Ballinger, you're saying from approximately the first 9 months or 10 months?
Approximately, sure.
Yeah,
That's what the agreement states, or the rate determination states.
on the previous page, I believe it begins with for the 12-month period prior to the effective date of the TAP rider. Are you including that in your question to me?
Correct.
I agree that it says that, yes.
And in this proceeding, isn't it true that PWD elected to use only 4 months of actual data? It's advance notice for projecting TAP R costs and revenue recovery for the future
Objection, we
period.
didn't choose, that's all we had. We
I'm
expanded that
sorry, no,
during the
I'm-
course of the proceeding.
That's not true, Andre. We just went over the participation data, including September 2024 through December 2025. So that's not factually correct. And I would ask the witness again, isn't it true that PWD elected to use only 4 months of actual data in calculating TAP R surcharges for the future rate period in its advance notice?
We did.
Thank you. And just to confirm the paragraph that we just went over in the 2018 rate determination, you would agree that that does not in any way limit what the public advocate may do in estimating TAP revenues and expenses. It's binding only on PWD. Isn't that how you read it? As PWD will use?
It does say that. I'll be quick to say that I'm not an attorney,
I understand. Thank
Mr.
you.
Ballinger.
I'm going to move on to page 20 of the rebuttal testimony. And I'm at line 15. Are you the correct witness to answer a question
Black
about
and
that?
Beach, if I'm not mistaken.
So maybe Mr.
I'm
Yod or
not.
Mr. Merritt?
Correct.
Mr. Yod or Mr. Merritt, is one of you prepared to answer a question about this section of the testimony?
Please identify the question and then the respondent will know.
I'm
that
at
that's,
page 20, line 15.
we're late waiting for the question and then we'll know.
Okay. The rebuttal, I don't know why this is so challenging this morning.
It's not. We're good.
I've had enough coffee. So do you agree? Well, let's just start with the statement that appears here. It states, in other words, Mr. Morgan is focused on factors and not outcomes. Isn't that correct, what your testimony states?
Correct.
Do you agree that the amount of TAP R surcharges are determined based on a formula?
As stated in rates and charges, section 10.
I was waiting for a yes or a no.
As stated in rates and charges, section 10.
Thank you. And that formula relies upon various factors, the components used to calculate the TAP R. Isn't that correct?
I'd have to look at the rate rider language to see if it specifies the factors themselves or whether or not it just defines what the C factor represents, what the E factor represents, and what the I factor represents.
And those are some of the factors, correct? C, E, and I.
Yes.
I just want to make sure that this section of your testimony is not suggesting that the TAP R rate be set at a certain dollar amount and then reverse engineered to determine the factors to slot into the calculation to achieve that. That's not what you're saying here.
Our rebuttal testimony was focused on the overall outcomes of the public advocate's witness in prior proceedings, the resulting discounts compared to what actually occurred, and whether or not we're effectively reconciling costs from period to period. This is the third proceeding in a row that we filed that we are continuing to under recover costs with respect to TAP discounts. So that is what we are trying to address. He says that we are unreasonable in our proposals, and that's what we were rebutting.
But you don't have a predetermined goal for how much revenue you want to recover. You're actually trying to calculate the TAP-R based on the input of the factors in the model. Isn't that correct?
Yes, that's correct.
And we're going to come back to the testimony probably after a break having to do with under recovery. So let me refer you to Public Advocate Hearing Exhibit number 1 at page 6. Tell me when you're there, please.
Number 1 at page 6.
Yes.
Sorry, Mr. Ballinger, the PDF page or the page at the bottom of the?
It's the page at the bottom, so it would be PDF page 7.
Yeah. Okay.
And this contains PWD's response to PA TAP set 4 number 1. In response to the question of whether the 0.25% monthly growth rate was judgmentally derived, the first paragraph states, and I quote, Raftellus used its experience, I'm sorry, let me start over. Raftellus used its expertise, experience, and subjective opinion, as well as the recent trend in participation to project the 0.25% monthly growth rate. Correct? And I believe that might be you again, Ms. Locklear.
Yes.
And as we discussed earlier, participation data included in PWD's rate rider reconciliation workbook is based on the period from September 2025 through December 2025, which is the 4-month period we referenced.
That's correct.
Isn't it true that the monthly data for that period does not show a 0.25% monthly growth in participants? Month over month?
Hold on 1 second. Please.
I can make it a little easier for you. Earlier, you agreed that November 2025, there was a decrease in participants, correct? Measured by the number of TAP bills.
Yes.
Okay, so there could not have been a 0.25% increase between October and November of 2025 because there was actually a decrease. Isn't that correct?
Right.
So am I correct to interpret the response to this discovery request that we referenced on page 6 of the Public Advocate Hearing Exhibit to mean that the September 2025 through December 2025 historical data was considered in deriving the projected 0.25% monthly growth rate?
It was considered.
And am I correct that when the 0.25% monthly growth rate is annualized, the result is a 3% annual growth in participants?
Yes. Subject to check.
Fair enough. Let's turn to the next page of the hearing exhibit. It's page 7. And this is PWD's response to PA TAP set 1 number 5, correct?
Yes.
And at the bottom here, the last sentence states, we anticipate that growth and participation will slow down further over the next period, such that the average rate of increase would settle to about 0.25% monthly, correct?
Yes, that's what we answered.
Could go back to the rebuttal testimony, and I'm looking at page 9. And so I think this is still for you, Ms. Locklear.
Okay. Please give me a moment.
No problem.
Okay, I'm on page 9.
And I'm at lines 6 to 8. And testimony states, the department receives regular updates from IDEA, including customers pre-qualified for enrollment in TAP. Do you see that?
I do.
Did IDEA provide any data to PWD that suggests that growth in TAP participants would be 3% over the next year?
No. IDEA doesn't provide projections.
Thank you. And in considering historical data to make a projection of future conditions, wouldn't you agree that more data points are preferable to less data points?
Often that's the case.
Do you believe that a 1-month growth in TAP participants can be considered to be representative of the expected ongoing monthly growth?
Not necessarily.
Can we look at page 8 of your rebuttal testimony, lines 8 to 9? And the
Yes,
testimony states, these observed increases contradict Mr. Morgan's assertion that program participation should not be expected to grow. Do you see that testimony?
I do.
Can you identify where in Mr. Morgan's testimony he states that program participation should not be expected to grow?
That statement refers to his zero growth assumption over the period that we previously discussed.
And you referred to zero growth multiple times in your testimony, but as we've already discussed, Mr. Morgan's average level of participation represents an increase from the historical 12-month average. Isn't that correct?
Yes, and as I stated before, it doesn't correspond to the expected increase that we have projected over the period. Just
And-
because the starting point is higher.
Just sort of, not to dwell too long, but the testimony refers to an assertion. Assertion usually refers to a very, clear and plain statement, not to a projected number. Isn't that correct?
Mm,
Can you agree with that?
I don't know if I want to quibble with you over the word assertion, but
It just strikes me that that you've characterized his testimony in a way that I don't believe it should be read. So
Objection,
I'll move.
argumentative.
Let's move to page 10 of the rebuttal statement, please. And I'm at lines 20 to 22. And I'd like you to confirm for me that the testimony states, Mr. Morgan suggests a flat TAP participation of 68,405 for the remainder of the most recent period, as well as for the next rate period. As explained in this testimony, the program has already experienced participation above this level. Isn't that correct?
That's what we state, yes.
Isn't it true that the growth pattern of TAP participants is not a linear pattern?
As measured from month to month, and
Yes.
as we talked about, because of the months with a shorter or fewer number of working days, those fluctuations are not linear. That's correct.
Thank you. I have some additional questions. I don't know if it makes any sense. I have in my outline here a pause if anyone needs it. So I'm happy to move along, or if anyone needs a break, we can pause. Okay, great. So your rebuttal testimony includes some discussion about why you believe TAP R rates are not recovering TAP costs, correct? I believe Mr. Merritt spoke to this earlier.
That's correct.
Or Mr. Yacht, thank you. I'd like to try to get some further explanation of one of the factors that are affecting TAP costs and recovery. I'd like you to turn to page 8 of Public Advocate Hearing Exhibit. This contains part of the attachment, the spreadsheet that was provided in response to PA TAP set 4, number 4. Is that correct?
Yeah, correct.
With
That's an excerpt.
Yeah, with one small change in that I've highlighted 3 cells, cells Z22, Z23, and Z24. Isn't that correct?
Correct.
Otherwise, those cells are unchanged. Do you agree with that?
Subject to check.
Okay. So the question that we asked PA TAP set 4, number 4, was for PWD to recalculate the monthly discounts from January 2025 through August 2025 as if the base rates that changed in September 1 were in effect, correct?
So by recollection, I don't have the specifics of that discovery request, how this question was stated. We can pull it up if necessary.
Yeah, I mean, I would like to be clear as to what the request was, if you don't mind. You could pull up your response to that discovery as well as it repeats the question.
Give us a moment.
This is PWD response to PA TAP R discovery set 4, question number 4.
Mhm. That's correct.
Okay.
That was the initial,
Go ahead, Dave.
that was the request.
Thank you. So in the cells that are highlighted, Z22, Z23, and Z24, in those cells, you calculate what you call the change in typical bill effective September 1, 2025. Isn't that correct?
That's correct.
And when I look at the $110.91 shown in cell Z22, am I right that represents the bill a non-TAP customer would receive for 6 CCFs of water billed under the rates in effect starting September 1, 2025?
That's correct.
Am I also correct that the $100.97 shown in cell Z23 represents the bill a non-TAP customer would receive for 6 CCFs of water billed under the rates in effect starting September 1, 2024?
$25.
Now I'm referring to Z23, which is the typical
Yes,
bill.
that's correct. Sorry.
Okay, so
Correct.
no problem. No problem. I know it's hard to keep track of the numbers. I'm doing my best. Thanks, Dave, or Mr. Yacht. Am I also correct that both of those amounts shown in cells Z22 and Z23 include the TAP R surcharge rates that apply to usage as at 6 CCFs?
Yes, that's correct.
And you would agree with me that the TAP R rates increased on September 2025, right?
Correct.
I'm sorry, I didn't hear.
Correct.
Thank you. So part of the calculated $9.94 difference shown in cell Z24 represents the increase in the TAP-R surcharge, doesn't it?
Correct.
Am I correct that the discounts that are relied upon in the advance notice are calculated as the amount that by the amount that shows up on the TAP customer's bill as a discount? The data comes from the billing system, in other words.
And I can state our understanding. It's a Raft-Hallas analysis.
Maybe Ms. Locklear can help me with this then.
Can you repeat the question, please, Rob?
Yes,
Or Mr. Planner?
the discounts for each TAP participant that you rely upon in your rate model are the actual amount of calculated discount that's shown on the TAP customer's bill. Is that correct?
Yeah, those are the ones that Raft-Hallas reports.
Thank you. So that discount is calculated as the difference between a total usage bill, including TAP-R surcharges, and the discounted bill amount based on the household's income. Isn't that correct?
Yes.
So that means the discount amounts that you've used in your model include TAP-R surcharges, do they not?
In our model, the discounts do reflect that simple amount. Yes.
So embedded within the discount calculations are TAP-R surcharges that TAP customers are not responsible for paying. Isn't that correct?
That may be the case, but I'll refer to Dave and Brian as to how that's accounted for.
Right. I will confirm that it's in there and there are adjustments if through the E-factor analysis, the TAP-R is removed.
But not for purposes of the C factor, correct?
No, it has never been removed from the C-factor, but we are also one rate increase behind. So while we are reflecting the rates in effect during September 1st, 2025 to August 31st, 2026, the C-factor is supposed to be adjusted or reflect the anticipated credits during the rate period for TAP-R.
And you're
At
using
which time we would be under September 1st, 2026 to August 2027 rates. And the increase in TAP in 2025 is less than the increase in the general rates.
So you're suggesting that by embedding TAP-R surcharges in the discount amounts, you are more accurately recovering a discount that has not been given in a future rate period? Is that the
I
suggestion?
think it's a better estimate than the previous rates, which are clearly understated.
Well, I'd like to go through an example of why this is problematic. I'm going to ask you to refer to page 10 of the Public Advocate's hearing exhibit. And I'm going to give you some background assumptions so we can walk through this scenario. We're going to assume there are 50 customers in the system, each of whom has a standard bill of $100. So the overall billing amounts are $5,000. Do you understand the scenario as I've laid it out?
Can you restate?
In this scenario, we're going to assume there are 50 customers in the system, each of whom has a standard bill of $100. So the overall billings are $5,000. You understand the starting point?
For your exhibit,
Yes.
Joseph.
Okay. Starting in year one, one of the 50 customers qualifies for a discounted bill of $50. And so all of the other customers, 49 of them, are imposed an equal surcharge to maintain total billings of $5,000. See that in the first row across, designated year one. That results in a $1.02 monthly surcharge. Isn't that correct?
You're asking for what the exhibit states.
Yeah,
That's all.
that's fine. Mathematically as well, it's not complicated math. $50 divided by 49 is slightly more than $1. Can we agree on that? Can we agree on math today? Do we agree that this is mathematically accurate?
We can accept that subject to check, Dave.
Fair enough.
Yeah,
So in the following year, the same customer continues to qualify for an affordable bill of $50. And now, to measure the discount, we start from what is the typical bill for the other 49 customers of $101.02. And now we've increased our discount amount by $51.02. It is increased to $51.02. Do you agree with that mathematically?
subject to check.
And as a consequence, we now have to increase our surcharge because we've increased our discount. So our surcharge now increases to $1.04 mathematically and subject to check.
Now, the increases in the typical bill in column, well, the typical bill column.
I'm sorry, this is the court reporter. Dave, your responses are a little muffled. If you and Brian are in the same room, can you swap? Brian, you mute, and Dave, you unmute your mic.
Sure.
Yep.
Thank you so much. I'm sorry to interrupt.
We're avoiding feedback.
So I'm asking about year two as a consequence of including the surcharge and starting with a typical bill for a non-tap participant to calculate the discount. Isn't it correct that that has caused the discount amount to be recalculated at $51.02? Mathematically subject to check.
As a clarification,
I'm sorry?
just trying to see how we're getting feedback. Oh. Can you mute yours for a second? All right, sorry, we had to mute the other computer. All right. So just as a point of clarification, the first column, the increases are not increases in the typical bill because of base rates. The increases reflect the base rate staying the same and the assumption that it's adding in the TAP-R or your proposed TAP-R hypothetically TAP-R
Correct.
to recover the discounts.
Yes, in our fictional 50 household system here, yes. That's what has happened. The surcharge has been included in the typical bill. And isn't it correct that mathematically providing the same level of an affordable bill for our one low-income household produces a higher discount amount as a consequence of that inclusion? Isn't that correct?
I apologize. All right, I apologize, Mr. Ballinger. I had my speaker turned down and did not turn it up yet.
That's okay.
We switched. All right.
Do you want me to repeat the question?
Yeah, well, yes, please.
Sure. So by calculating the discount from a typical bill that includes the $1.02 surcharge to deliver the same affordable $50 bill to our low-income household, we now have increased the discount to $51.02, correct?
Mm.
Mr. Ballinger, in your example, you've provided a hypothetical for us. The numbers tell us what you have reported, and we're agreeing with you as to the numbers in your hypothetical as stated on that page. We're not endorsing it for any particular purpose. We are not your witnesses.
That's fine. And I realize this, is something that is a little bit different, but it was something that came up as a result of the discovery response. And I think directly addresses PW's claims regarding under recovery, because in fact, the discount amounts are calculated to include TAP-R surcharges. The surcharges are embedded in the discounts. Isn't that correct?
That's correct. And as we stated, it's adjusted in the E factor and when it's reconciled.
And as shown in this illustration, that caused the impact of including the surcharge also affects the surcharge. Correct? The discount amount is higher, and so the surcharge is higher. Isn't that correct?
That's correct. However, it also reflects no increase in the typical bill, which is not our case.
Would you agree that if there were more participants in this scenario, the impact of including the surcharge in the calculated discount would be greater? All else remaining the same?
Can you repeat your question?
Would you agree that if there were more participants receiving discounted bills in this scenario, the impact of including the surcharge in the calculated discount would be greater?
In total revenue, because it just would ramp up, the factor up by the number of participants. Correct. But again, any over recovery would be recovered by or adjusted in the subsequent TAP-R and reconciled. However, I doubt that there would be because of the increase in base rates, which offset this included.
But you haven't calculated any of that in this proceeding. You haven't calculated an
Well, I
offset.
calculated the impact. I calculated the percent increase of TAP-R between the years and compared that to the base rate increase in 2027. And the increase in TAP rates is lower than the increase in the base rates for fiscal year 27.
The per CCF, are you talking about the use, just simply the surcharge compared to the per CCF charge for water and sewer?
You have to include the total bill
Total
for
bill,
the increase in base rates. So if
because
you compare
stormwater-
the typical bill with those rates, the typical bill would increase by more under base rates in 27 than the increase in TAP-R rates.
So that sounds like a different methodology than what you've put forward in this case, because in fact, your C factor is based on the discounts. It's not based on a historical average from the bill minus surcharges with a projected impact of the base rate increase, is it?
So it's within the process of how we project the C factor. And it's a known fact that we are behind in estimating the C factor based, even if we use the averages based on the current period rates are the rates, right? For example, right now, they're the rates through August 2026, which will change September 1st, 2026, and increase the discounts that we experience. This is one of the factors that contribute to the fact that the department continues to under recover TAP R.
Under recover measured based on a discount level that includes TAP R surcharges, correct? Your discounts, we've just talked about it. You're under recovering an inflated amount of discounts because TAP R surcharges are included in the discounts.
That's not correct, because when the recovery is done with the E factor nets out the TAP charge in the discounts.
And the E factor refers to prior years, correct?
Correct.
Not the
which is
projected year.
Yes.
So they've been included for the future period, but your statement is that the past year periods in which they've been also included is somehow netted out through the E factor. But isn't the E factor increasing in this proceeding?
Yeah, but the E factor is increasing because we're under recovering.
Because it includes TAP R surcharges.
No, it's net. We net. If you look at the tables, let me pull up our testimony.
Are you going to the advanced notice?
Yeah, I can do that.
I will try to do that as well.
Sorry, it's going to take me a few minutes, but. Sorry, click on that like 3 times to get it. All right, there you go. This is the rebuttal statement. All right. Whether we refer to the rebuttal statement or the original filing, tables 3W and tables 3WW, which are the development of the E factor. Column 1 presents the discounts, including TAP R revenues to TAP customers. Column 2 and 3 develop the TAP R charges to TAP customers. The next column reduces the credits for the TAP R charges. That credit is compared to the TAP R, or the TAP R revenue from non-TAP customers to develop the over or under recovery. So the E factor excludes TAP R revenue from TAP customers.
Okay, thank you for walking me through that.
So again,
about that.
it's showing the total for the recovery is negative, showing it's under recovering.
And again, this is based on the discounts from a prior period or prior periods.
Correct.
I'm sorry, which table are we referring to at this point? This is Mr. Bakare.
Yeah, Ade, I'm looking at In the advanced notice PDF, page 8, if you have that handy.
Table 3W in the
Table
schedule
3W.
PWD 1.
Yeah, there's two. There's table 3W and table 3WW.
Okay. Thank you.
So I would like to conclude with the transcript request, please. And it's in two parts, so I'd like this to be designated PATR number 1. Part A, please recalculate PWD's spreadsheet model to remove the embedded TAP-R surcharge used to calculate discounts in the C factor for all relevant periods, including the 12-month period utilized in the public advocate's testimony. Part B is to specify each change made to the models in response to Part A and redistribute the resulting workbook.
Connor,
Mr. Bowser,
please.
you,
We object to this particular transcript request because if anyone was to do this, it would be Mr. Morgan, not our witnesses. And if he wants to present something as a part of his testimony, we get it. But when you're revising your testimony the day before and doing a substantial errata that affects the whole proceeding, it just seems like a transcript request is prejudicial to the department and shifts the burden to the department, which really belongs with
No,
the
it's your
public advocate.
rate. The proving the necessity of the rate is the utility's burden in every form in which utility rates are set. Now, this is a request based on the response and the revelation that the C factor includes TAP-R surcharges. They're embedded in the cost being passed on to other customers through the TAP-R surcharge. It's not that complicated either, because you just take the TAP-R surcharge, the sum for water and sewer, divide it by 10, and then multiply it by the usage amount. And surely I could do that, but I would like for the department to do it. It is their burden and it is their spreadsheet. We're not taking ownership of it. So that we reiterate our request.
And we express our concern that we're shifting the burden of the public advocate, making its position, supporting its position, providing credible evidence to support its position, not revising its testimony at the last minute and then pivoting to it's our responsibility. It is not. It is it's department's responsibility to put forward their case. We've done that. We've also indicated the problems that we see with his simplified approach, which sort of looks past the E factor and makes numerous adjustments to the C factor. And as we'll get into in later in our testimony today, the errata in and of itself, the revisions in and of itself creates problems in terms and prejudice in terms of our presenting our case. To shift now the burden to we need to or are requested to provide data to support his position, we suggest that's wrong, particularly on the date of the hearing.
Well, this is not the position taken in Mr. Morgan's testimony. This is the cross-examination really focused on the rebuttal and the discovery that was issued or provided to us on Monday of this very week. That's where this information comes from. That's where we started this cross-examination. That's why we're asking this question. It is directly responsive to the department's claims that it is under recovering because the costs it has projected are escalated. They're artificially increased by TAP-R discounts, which TAP customers do not pay and are not and should not be presumed to pay. That is the basis for the request.
We just walked through the exhibit showing the E factor, 3W and 3WW, that shows it was deducted. And so we're sort of at an impasse. The hearing officer will have to sort this.
How difficult would it be for the department to put something together?
I can talk with Black and Veatch at the break, and we would endeavor to do whatever you ask us to do, but we want it in the context of this hearing and the fact
I
that
hear
so
what
much
you're
is done
saying.
at the last version.
I hear what you're saying, and this is an argument.
Yes.
And You're going to argue your original numbers are
Correct.
proper, and you're going to argue the other numbers are proper.
That's correct. And we would like to support our numbers and suggest that Mr. Morgan support his. Public advocate.
I understand that. If you can do it without a lot of extra undue, effort.
And I will consult with Black and Veatch and RFC at the break, and I can give you a response in terms of timeline.
Okay.
And that was actually the conclusion of my examination here today. So thank you.
Hearing officer, I have a question. I did not indicate cross for Mr. Yacht, but this was an unusual line of questioning on an issue that wasn't addressed or fleshed out in the department's testimony. And if permitted, I would like to just ask a brief question or two on the topic that was introduced by Mr. Ballinger through his cross on this question of the incorporation of the TAP discount into the E factor.
Is this cross directly related to the cross provided by the public advocate?
Yes, I will be very narrow in my questions.
Okay, then I will let you go ahead. But Mr. Haver did indicate he has some cross also. But if it's directly related, we'll let you.
Mr. Yacht,
Okay.
if I were to use a term to address the concerns that you raised with the reason for your increasing the discount in the E factor to reflect to reflect the TAP R, would I be correct in saying you're concerned about the regulatory lag that would impact the revenues if you did not calculate it as you do?
Okay, for clarification, the EFACT, this is an indication of the billing system. The current billing system has a quantity charge or the volume charges for water and wastewater. There is not a separate volume charge in the billing system for TAP R. TAP R is added to the base rates when the bills are developed. Is not separated. So this is why this is done this way in the E factor table, that bills go out, including TAP R. And then for a TAP bill, it's developed reflecting TAP R rates in the original value prior to the adjustment to reduce the bill down to the income-based levels and reflecting the discounts. So when we get the discounts at first, it does include TAP R. That's why the whole process in the tables developed in the TAP R reconciliation. When the reconciliation is done, the first step we do is adjust or net down the TAP R discounts for the amount that's included for the TAP discounts. It removes the amount that's being embedded in the bill, in the original discount provided. So TAP R, when we look at the reconciliation of TAP R rates, it's not included. we are only recovering discounts net of TAP R rep charges to TAP customers. It's not a factor.
But is it a factor in, forget about the reconciliation for a moment, is it a factor in the calculation of the discount that's going to be applied in the next billing period?
So the regulations define the C factor as a projected, like an anticipated level of credits to be provided during the next rate period. So during that period, we are going to experience higher billings from the new, like the rates, base rates becoming effective. So this is an indicative problem that establishing the C factor based on historical credits, which are based on lower rates, we are continuously under recovering the future rates. And
When you
even
say-
with, go ahead.
When you say lower rates, you're now talking about the base rates, correct? The base rates that will be changed on September 1?
That's correct.
Okay.
So what we were pointing out too before, and we checked that even looking at the fact that the current rates, so like in fiscal year 2026, the TAP R that's included and it's determining the discount and how it's included in our current C factor is still far less than the increase we're going to see from the base rates in 2027.
So
And
the concern
let me
is
correct
trying
myself.
to,
I'll say less right now because I don't recall the specific difference. So I don't want to overstate that it's far less, but I know for sure it is less. So I know we are definitely still in a position to under recover even with our proposed C factor.
but you would agree that this TAP R reconciliation process is not really intended to address any concerns related to base rates.
That's correct. I mean, it's not, well, the issue is that the prospective credits that TAP customers will receive in 2027 are impacted by the fact that the 2027 base rates are increasing. So as a result of increased 2027 base rates, PWD will have to provide higher levels of credits to cover the increases in the bills to TAP customers prior to TAP discounts.
That's all the questions I have, Hearing Officer. Thank you very much. Thank you, Mr. Yacht.
And I believe Mr. Havers has some cross-examination.
Good morning. And I'm not particular about who answers from this panel. We just heard from Mr. Yacht about past rates. How much have the combined water, sewer, and TAP surcharges gone up in the last 6 years?
We suggest that we do it as a transcript request as the current proceeding is subject to the current proposed increases and current, I can, offhand, we have the increase from
If
like
you
the
want to
25 and 26, but
going back, if you want to make it a transfer, a request from the transcript, that's fine if you don't have it on the top of your head. It would just seem to me you've been referencing rates for past rates for quite a while, and it would seem to me that this would be a priority. But if you don't know it, you don't know it. I'm happy to make it a transcript request.
All right. I know, I'll acknowledge it increases, but the specific percentage,
The percentages and the amounts, again, the total bill, the base rates, water, sewer, and the tap surcharges, and the service rates, all told. In reading
correct,
through,
but can I clarify one thing,
of
Mr. Haver?
course,
The, can we use the typical bill amount that, like, our typical residential customer?
that would be fine.
Okay, just want to clarify. Thank you.
That would be fine.
And just so I have the wording right, Mr. Haver, we're going to calculate for the past 6 years the increase in base rates and tap R charges for the typical bills for typical residential customers?
Yes, and that again includes the service charge and the storm sewer charges, all of it.
Okay.
I recognize that your testimony is technical in nature, and perhaps in reading through it, I missed something. I did not find a factor that took into account the affordability of the surcharges on the people who don't qualify for TAP but have moderate income. Did I miss that?
No, the TAP-R is a reconciliation process, and it's the formula and the approach is all based on the formula that was already established by prior general rate proceedings and reflected in the rates and charges of the department.
So there's no calculation on whether it remains affordable as it goes up on lower middle class, lower working class people. Is that correct?
Within the proceeding, we present the impact to the typical customers, so it can be considered during its evaluation, but the primary drivers in a reconciliation is the level of rate needed to continue to provide sufficient revenue to cover the credits
Right. Again,
provided in the TAP program.
I think I understand. You're saying, according to the formula, the affordability of the bill is not part of the formula. Have I understood that
Correct, but the
correctly?
information is provided to evaluate the impact.
And
Because the requirements of a TAP rate proceeding require that you provide the impact to the typical bill.
did you see anything in the advocate that's appointed by the rate board's testimony that addressed the issue of affordability of the surcharge?
Again, because of the premise of the proceeding?
Dave, hold for just a moment while I offer an objection.
Sure.
Your Honor, this is a question of the rate board's calculations, not of the advocate's calculations. We'll have an opportunity to ask the advocate's witnesses about their testimony, but it is improper for him to seek that information from rate board's witness. We object to the relevance of that question to the rate boards.
And I will explain the relevancy. We just heard from Mr. Yacht that he doesn't consider in this formula affordability of the bills for the TAP-R reconciliation. I'm asking him, in his professional opinion, if other people do consider it.
My objection, because that is not water departments. I renew my objection because that is simply not a part of the water department's testimony.
I agree that you should ask questions of the individual who actually provided the testimony. So that would be appropriate to ask.
It's not a surprise to me that when the water department objects to providing testimony, you say they should do it anyway. But when I'm asking for information, you side with the water department. You might want to talk to Mr. Popowski like you have done off the record before you make a decision.
Advocate's witness is here. You've signed up to cross-examine the advocate's witness. So I'm not even sure why this is an issue. You'll get the answer from the witness who provided the actual testimony.
Again, I note that before, when you were ruling in favor of the water department, you spoke with Mr. Popowski off the record. Highly inappropriate. And here, you're saying that I don't have a right to ask a technical expert, and he is an expert, whether he has read other testimony that takes affordability into consideration. I did ask that. That's precisely the question I asked. I didn't ask him to interpret it. I asked him specifically when he reviewed the other testimony in this, what you call reconciliation, and what people who have to pay the bills call a rate increase, whether there was any testimony introduced by the rate board's advocate that talked about the affordability of the TAP surcharge.
Your Honor, if I may, the transcript is certainly available to be read back if necessary, but I just want to note early on in this proceeding that it is a good thing that a customer of the water department is physically here to state his views on what has been filed. However, as a participant in this proceeding, he must operate according to the same rules as everybody else. And with respect to discovery, with respect to the rules of evidence, with respect to what one can and cannot ask the witnesses, he must be held to the same standard that we are held to.
And it's unfortunate that such a learned man has not read the Pennsylvania Supreme Court's decision on pro se litigants.
How do you know I haven't read it?
Well, then why don't you recite it?
Just because I don't recite it does not mean I did not read it.
Then you would know that the ruling has been that pro se litigants are given greater latitude and do not
say that wasn't true.
Okay, so now you're saying I have to adhere to.
You have to adhere to the same.
I am a pro se litigant and I get the protections that the Pennsylvania Supreme Court awarded me.
But you don't get the ability to throw out the rules of civil procedure, the rules of evidence, or the rules of administrative practice.
Does standing make your words more important? The Supreme Court has said that pro se litigants get latitude in how they ask questions, how they file requests, and how they ask for testimony. You are denying that decision, sir?
No, I'm not denying the decision, but I am denying you the opportunity to ignore the rules of the court.
Again, my question is, did he read in any of the testimony filed by the rate board's advocate that the issue of affordability in recommending the TAP rates was raised?
Question that I objected to.
If the question has changed to have they read it, then that is a proper question. That is the question before us now, and that is proper.
That's my question. I'm waiting for a response.
You understand the question as it's currently constructed?
Okay, just to be sure, can you repeat the question one more time? Sorry.
When you read through the testimony of the rate board's advocate and their experts, did you read any testimony that talked about the affordability of the TAP surcharge?
If you know, Mr. Yacht, if you know.
Yeah, I do not recall offhand. Like any particular statement, but I know for sure, again, within the confines or the paradigm, what we're looking at within a TAP R proceeding, Mr. Morgan presents both our projected impact to the typical bill as well as his proposed adjustment to the typical bill under his conclusions. So I know there is information to consider the impact. I don't recall if he makes any further statements, but the information he provided is appropriate within the confines of this proceeding.
Thank you. How many of the last 6 TAP conciliation proceedings have been settled through settlements with the rate board's advocate and the water department?
Just to cut through all of this, Mr. Haver, all of the TAP-R cases have
Yeah.
settled.
That's my recollection as well. I was
So all the
subject to
last 6 years have settled. In coming to your recommendations, is the public input important?
From our recommendations, again, our testimony presents the projected TAP R rates based on, our application of the TAP R formula and the historical data.
So the public input hearings aren't important to your calculations?
Not with the calculations, no.
That was an objection because he misstated the testimony of the witness.
Okay, sorry.
I believe he's also answered the question, so we can move on.
Do you know how many people attended the last public hearing on the TAP reconciliation?
Objection beyond the scope of the witness's testimony, and the record will speak for itself when you can count them yourself how many people were in the room. You were here.
I asked if he knew. I didn't ask if I knew. He either knows or he doesn't know. He doesn't know, he doesn't know.
I listened to the recording. The recording didn't provide any video to see participants or anybody in the audience, or even the number of participants that called in to listen online. It's difficult to say how many participated just listening. I know, can't recall if it was us. I know yourself spoke, and I think one other person spoke.
Thank you. I just want to make sure I understand. Someone who's on the TAP program is paying a percentage of their income for their water, sewer, and service charges. Have I understood that correctly?
Qualifying customers for TAP.
Yes.
That's correct.
Do the people who pay the surcharge for the TAP pay a percentage of their income to cover the bills? The surcharge part of the bills?
Non-TAP customers receive a bill based on their usage and meter size.
Unlike the TAP recipients who pay a percentage of their income, the people who pay for the program pay a flat rate. Is that correct?
They don't pay a flat rate, but they pay the bills based on the base rates in the TAP R.
Thank you. So a person making $40,000 a year pays the same tap surcharge based on usage as a person making $400,000 a year. Is that correct?
Assuming they would not be qualifying for a TAP program, because I don't know how many household participants, and offhand don't remember the scale for the allowable income, depending on the number of household members. I would say yes.
Thank you. Can the Philadelphia Water Department accept grants and transfers from local, state, and federal governments?
Objection, beyond the scope of the testimony of the witness in the first instance, and I don't think it's relevant to the TAP-R proceeding also, because the only grants that I can think of are like Pinvest loans and the like for capital projects.
The relevancy is the next question, which is if the city were to take 1/10 of 1% of its annual operating budget and dedicate it to pay TAP, would that be sufficient to cover the costs?
I think we'd have to have the number of the total budget in front of Mr. Yacht so he could do the arithmetic. If you want to make that a TR, we certainly.
That's fine. If he doesn't know the city's operating budget and he wants to have a look, it's roughly $6 billion, and that's not accounting for the water department's budget or PGW's budget or the aviation department budget. But you have a look and calculate it however you want. Again, the request is, would 1/10 of 1% of the city's annual operating budget cover the entire expense of the TAP program?
Just to be clear, Your Honor, I understand that the Water Department has taken that question as an on-the-record request. But the initial question is different from that one, and I'm asking if Mr. Haver is withdrawing the initial question.
No. Initial question is, can the Water Department receive grants from local, state, federal government foundations? The question was raised, what's the relevancy? I just showed the relevancy. So the first question, of course, stands.
Objection remains as well.
If you know the answer to the question, you may answer the question.
So it's Mr. Desant pointed out, the department does receive grants and for capital programs. I did do a quick search before this proceeding to check of like availability of grants, and typically any grants that are provided to cover billings are typically provided to the customers directly, like the LIHEAP program that was available during COVID. It's not typically provided to the utilities themselves.
Thank you. Does everyone who does business in the city of Philadelphia pay the TAP surcharge? For specifics, a construction company based in Villanova that's building a high-rise, do they pay into the TAP? Do they pay a TAP surcharge?
Are they a customer would be the question.
No, they're not a customer. They have no water usage. They're not connected. They're just building a high-rise. Let's say a condos that start out at $3 or $4 million each. Do they pay a TAP surcharge?
We could stipulate to that, Mr. Haber. If they're not customers, they don't pay.
Are they ever asked to contribute?
We
So
can
I'm
stipulate
asking
that
the-
if they're not
yeah.
customers, Dave, We
Well,
can
there-
stipulate if
it-
they're not customers, Dave, they do not pay.
Right, I'm not asking now, we answered that question. I'm asking if they're ever asked to contribute to the burden, to lessen the burden of poverty in the city.
It's beyond our testimony.
Thank you.
I'm objecting to the scope of that question. Anybody, anywhere asked to contribute to the water department is absurd. So I object to the relevance of that question.
Again, what a surprise. So people who are speculators in our city, who buy and sell stocks and bonds, buy and sell businesses, they don't contribute unless they are water customers. Is that correct?
That's beyond the scope of our testimony.
That's it for me today. Thank you.
If Your Honor, please, if there are no other questions from other participants, if we could have a break, we could speak with Black and Veatch and Reftelis offline and then come back with any redirect if we have any. 10 minutes, probably a little more.
Okay, we are going to take a break. Let's do 15. Meet back here for redirect. Okay, and we're back. We're at the point of redirect.
Thank you, Your Honor. Let me direct the first question to the Black and Veatch panel. We discussed this morning with the public advocate, the C factor and the E factor and how they were calculated. Can you tell us how these calculations align with the overall goal of reconciliation?
So the goal,
Andre Desant for PWD. Mr. Yacht, go ahead.
all right, the goal for the reconciliation is that ideally TAP-R rates would be set at a level that provides the department with sufficient revenues to cover the discounts during the projected or next rate period. Ideally, when that projected rate is reconciled in a future year, our E factor, the goal would be to set the rates so in future proceedings, the E factor under these current rates would result in a zero or no reconciliation required to balance the revenues with the TAP credits provided. We have proposed several adjustments or consistently proposed some adjustments through the TAP-R rate proceedings to improve the recovery of past reconciliations. One of those things is to continue to present the department's positions that we need at least the projected TAP-R, the C factor, to consider the discounts provided under the current rates. We know that under the current rates, we're still underestimating the C factor, the potential C factor for the next rate period, because during the next rate period, the rates will be higher. So, you know, we also know that the continued approach proposed by the public advocate in this proceeding and prior proceedings to use 12 months includes discounts based on rates from 2 rate periods before the proposed rate period. So we know we're developing or including credits that understate the credits that we're going to be providing. And this continued approach results in under recovery. This is one of the reasons why the department in the past 2 rate proceedings for TAP has recommended that we use develop the credits based on the period of actual data under the current rates. Our testimony in the rebuttal clearly demonstrates that if we have used the 12-month approach or even the settlement approach that is, sometimes even a slightly higher rate or a rate above what's proposed by the public advocate, we are continuing to under recover. So the department continues its position to try and make adjustments to improve the recovery. So in future reconciliations, the E factor will come closer to a zero balance.
Thank you. A second question. The public advocate referred to the public advocate hearing exhibit at page 10 of his packet. The page is entitled Example of Embedded Surcharge. There's a table on that page that we walked through, at some length. What does this page inform us about this proceeding and the outcome that we should be expecting if we have a true reconciliation?
The exhibit, the hypothetical scenario that's being laid out by the public advocate, doesn't take into account several factors that we experience in, the actual TAP-R application. One thing for sure is he's assuming zero increase in typical bill for the projected years. When there is no future years or increases, the proposed scenario is like unrealistic to some extent. However, it's also an incomplete analysis in that it does not roll any over or under recovery into the E factor, which would adjust future reconciliations or TAP-Rs. So in the case where he's setting a zero base rate increase and the C factor would be, based on previous discounts or TAP bills, it has the potential to over recovery, but it would subsequently be recovered or settled through reconciliation.
Thank you, Mr. Yao. Thank you, panel. That's all I have.
This is Robert Ballinger for the Public Advocate. I have no recross.
No recross from Mr. Haver. From Plug.
No recross.
Well, that brings us to about lunchtime. I'm told that an hour is sufficient. So let's have a break. We'll see you back here at 1:10-ish. Okay, we're back on the record. Next up, we have the public advocate calling your witness.
And Mr. Morgan, are you able to unmute?
Yes.
Okay. Already stipulated to the, and I'm sorry, I'm Robert Ballinger. We've already stipulated to the authenticity, I don't know why that's so hard for me to say today, of Mr. Morgan's testimony. I do want to acknowledge that we distributed an errata yesterday in advance of the hearing, that it responds to some of the observations in PWD's rebuttal. We ask that be included on the record. And with that, Mr. Morgan, available for cross-examination.
Thank you. With your permission, Your Honor, we will proceed. Good morning, or actually good afternoon, Mr. Morgan.
Good afternoon.
As you know, I represent the Philadelphia Water Department in these proceedings. My name is Andre Desant for the record. You've provided direct testimony in this proceeding, correct?
That's correct.
Okay, and that's PA Statement 1. And this
Correct.
proceeding is a reconciliation of the Tiered Assistance Program rate rider surcharge. Am I correct?
You're correct.
Now, Mr. Morgan, if at any time during my cross-examination today you don't understand a question, just tell me and I'll seek to clarify it. And please also know that my questions today will relate to your direct testimony and can be answered with a yes or no, so that you can answer yes or no, and that's what I'm asking you to do, okay?
Okay. Just pardon me. I think I'll need you to speak up just a little bit or get closer to the mic.
Great.
It's coming in low.
And of course, if you feel you need to explain something, you can do so. That's my
Okay.
final introductory remark. Now, so let's talk about why we're here today with TAP-R. Would you agree that the primary purpose of this proceeding is to establish TAP-R rates sufficient to recover TAP credits for the next rate period and reconcile the actual and TAP-R revenue with actual TAP credits provided during the prior and current periods? Isn't that correct?
I would say that it's designed to collect what is prospectively expected to occur during the next 12 months, during the TAP period. But other than that, I agree with your statement.
Okay, and so you agree to reconcile the actual TAP-R revenue and actual credits is also a part of the reconciliation process?
That's correct.
Now, would you also agree, depending upon the department's actual experience, that rates and charges for the next rate period may be adjusted up or down?
Yes, that is how it's designed.
And moreover, would you agree that ideally the E factor, meaning the over or under collection of the TAP-R surcharge, and the I factor, meaning the interest on over or under collection of the TAP-R surcharge, would be close to zero, ideally?
Ideally, but I don't know if that's realistic, because one can never get the projection 100% correct.
But I'd say it differently. In an ideal circumstance, and tell me if you agree, the projections made in this proceeding will align with PWD's actual experience in the future, and the utility wouldn't collect any more or less from its customers than is needed, ideally.
Ideally assumes that, yes, the projections were 100% accurate.
Now, Mr. Morgan, let's talk about the projected number of TAP participants in the TAP-R filing. Isn't it correct that the department's TAP-R filing, and I mean by that the advance notice and formal notice, the department projected 69,356 TAP participants at the beginning of the next rate period? Will you accept that subject to check?
Could you repeat the number, please?
69,356 TAP participants projected as of, yes.
I'm sorry. Subject to check, yes.
Thank you. And TAP participants are projected by the department by the end of the next rate period, or August 2027, based upon an anticipated monthly growth rate of 0.25%. Isn't that correct? And I'm referring now to the department's filing.
Yes, the department's filing was based on a projected escalation rate of 0.25% per month.
Based upon the department's projection in its filing, 70,318 average monthly TAP participants are anticipated during the next rate period. Isn't that true?
That sounds correct. I'll accept it, subject to check.
In contrast, your testimony, in your testimony, you project 68,405 TAP participants throughout the next rate period. Isn't that true?
That is correct.
And you remove, or at least do not apply, a growth factor as assumed by the department. Isn't that true?
I did not accept the department's growth factor.
Rationale for rejecting the growth factor, as I understand it, is you expect that growth of TAP participants will eventually flatten out. Am I right?
I expected it to, or stated differently, the department stated that they expected that the growth would not be, would level off eventually. And so I chose a level that exceeded what the average number of participants were during the 12-month period that I looked at. So essentially, I factored in some growth.
And as I understand it, though, when you're referring to the department's statement, you're looking backwards in time to a proceeding or so before, where a projection was made and that particular statement was made on the record. Am I correct?
No, it was made in this proceeding.
So let me then proceed. You recommend holding the average number of TAP participants constant, preceding or leading up to the next rate period. Am I correct?
I am holding it based on the average number let's see. I'm holding it until the next proceeding, yes.
And your projection is based upon data that I see in the production data that was provided to you on April 15th that indicates in March 2026, the level of participation would be the number that you've used in your testimony. 68,405. Is that correct?
That's correct. But I point out that that is higher than the average for the most recent 12-month period, for most recent year. Yes.
Before leaving the subject area, can you confirm with reference to Schedule PWD 7, which is in the packet that I shared with you as PWD Hearing Exhibit 2? Can you confirm with reference to PWD 7, subject to check, that there was an overall increase of some 3,000 TAP participants shown in actual data for April 2025, which shows 64,762, through March 26, which shows 68,413. Can you confirm that that is shown in the data? And you can do that subject to check.
Please bear with me.
Just quickly to acknowledge that you're just asking Mr. Morgan to confirm what's in the department's hearing exhibit,
Yes.
but not to confirm the accuracy of those numbers.
But to confirm what's in the exhibit, that's true. Yes.
I'm pulling that up, please. I'm sorry, which exhibit was that?
PWD Hearing Exhibit 2 at pages 7 and 9. On page 7, you'll see April 2025, and the data there is 64,762.
Yes.
And flip to the next page, March 26, or 2 pages, and you'll see 68,413 for March 2026. Am I right?
Yes. Yes.
And will you accept, subject to check, that the compound monthly growth rate of 0.5% is evidenced by those 2 numbers?
I haven't calculated it, but I don't accept the compound growth rate because it doesn't capture fluctuations from month to month. With the compound, you're looking at 2 points in time. So it doesn't capture the average growth rate.
And would you agree, though, subject to check, that the TAP participant level, March 2026 of 68,413, as shown in Schedule PWD 7 or PWD Hearing Exhibit 2, is already greater than your projection of 68,405 in your testimony?
It is, but you have to keep in mind that if you look at the historical data from month to month, some months it goes down, it actually decreases. And so we can't just look at 1 month and pass judgment on it.
But in case of your testimony, you do take that 1 month, March 2026, and hold it constant throughout the next rate period. Isn't that true?
That was for the projection period. That was not for purposes of calculating the growth rate.
And let's talk about the average TAP discount per participant. And I'm referring now again to PWD Hearing Exhibit 2, which is the schedule PWD 7 excerpted.
I'm sorry, what's the PDF page, please?
I'm going to refer to the whole exhibit. I'll give you a page when
Okay.
Page 3. Let's look at page 3. With reference to PWD 7, would you agree that the average monthly discount for all TAP participants as shown in that schedule is $64.50? And that's shown on page 3.
I would just object. I think you're limited to a particular time frame to reach that conclusion, and there are lots of different estimates on that page that could be derived from the average number of participants, total number, and total TAP discount. So can you clarify what you're asking Mr. Morgan to look at?
Looking at page 3 of PWD Hearing Exhibit 2, and you look under in the left column, monthly cost per TAP participant, doesn't it show $64.50 to be the projected average monthly discount at that particular time, particular schedule?
Based on what's presented on that page, yes, that's what's shown.
And Schedule PWD 7 is based upon actual data through March 2026. Do you agree?
In production data?
That's actually static data if it's PWD 7. But the data, whether production or static, aren't so different in this particular proceeding. But if you're looking at PWD 7, isn't it based upon actual data? It actually even says it on the exhibit itself.
I'm flipping through.
Page 3?
I'm looking at page 3, but then you mentioned PWD 7, so I'm trying to go to that page.
The same document.
Could you repeat your question?
On page 3, with reference to page 3, you agree that Schedule PWD 7 is based upon actual data through March 2026. Look at the top row under scenario, and then all the way down, per participant data, most recent period, actual data. That's what it says, isn't it?
Yes.
That's what it says. I think that's the extent to which Mr. Morgan can verify the actualness of data he didn't produce.
Mr. Morgan, didn't you rely on data produced by RFC in PWD Schedule 5 as production data that you're using, in fact, for your projections in this case? Isn't that true? So throughout this case is my point. You're relying on data produced by the department. And sometimes you're embracing it. And PWD 5 is sort of a cousin of PWD 7. Same subject matter, later point in time. Do you agree?
Mr. DeSon, I apologize, but I'm just having a little bit of problem when you reference PWD 7 and page 3, and then there's I'm just having a little bit of trouble making sure I'm looking at the right exhibit.
Well, if you look at,
I could accept your number subject to check, but
okay, but if you're looking at PWD Hearing Exhibit 2, which is an excerpt of the schedule PWD 7, I'm
Okay.
looking at page 3, and that's where so many of the information I'm asking you is coming from. It says actual data on that page. I think you've agreed to that, and you've accepted subject to check that, you know, that data is produced by RFC, basically, the department.
right.
Okay,
So what's your question again, just so that we're clear?
sure. Based upon PWD Hearing Exhibit 2, which is an excerpt of PWD 7, is that based upon actual data through March 2026? Do you agree?
Yes.
Okay. Now, it's my understanding that the projections in PWD 7, which is also PWD Hearing Exhibit 2, are based upon 7 months of actual data, September 2025 through March 2026. Do you agree?
Yes, that's what's shown.
And in contrast, your testimony, and that's 7 months of data. We've agreed to that. In contrast, your testimony indicates 12 months of actual data is appropriate, and you're looking at April 2025 through March 2026. Am I correct?
You're correct.
And you estimate the average monthly TAP discount for the next rate period of $59.47. Isn't that true? Grab that on your testimony. I think it's something like page 6.
Yes. I know what was in my testimony. There were comments made by Lack and Veatch about some discrepancies, which I agreed with and corrected. And so I'm just making sure that what I'm agreeing to is the corrected numbers.
And you can accept that subject to check because I literally took that out of your testimony.
I'll accept the subject to check.
And to be clear, the average TAP discount in a given month would depend on several independent factors that include the number of participants, the income profile of the participants, the usage of the participants, and the base rates in effect at that time. Isn't that true?
That is correct.
Now, in the last base rate increase, if I recall, became effective September 1, 2025. Isn't that true?
That's correct.
Now, subject to check, the percentage increase in the bill for a typical residential customer using 430 cubic feet monthly as a result of the 2025 base rate increase, which became effective September 1, 2025, was about 9.4%. Do you agree? Subject to check.
Subject to check, yes, I agree.
And also subject to check, the percentage increase in the bill for the typical residential customer using 600 cubic feet monthly as a result of the 2025 base rate increase was approximately 9.8%. Will you accept that subject to check?
I will.
Okay, so your proposal to look back 12 months to calculate the average monthly TAP discount includes a period April through August 2025 that predates the current base rates. Isn't that true?
Yes, and part of this is because what I was trying to do was to compare a short period used by PWD, which was claimed to be representative of the customer profile, but that is such a short period that I do not believe it captured everything. So I went back 12 months to make sure that that we had a better feel for consumption data, number of participants, and so on.
Okay, I understand that, Mr. Morgan, but in looking back to calculate the average TAP discount, during a period April to August 2025, that predates just factually the current rates that are in effect now.
Yes, it predates, yes.
And base rates were lower during this period, April through August 2025, correct?
Yes.
Now, one important purpose of this reconciliation proceeding is to project the total TAP discounts or total billing losses for the next rate period. Am I right?
Yes.
Okay. And for the record, the next rate period is September 2026 through August 2027, right?
That's correct.
And arithmetically, you agree that using a period with lower base rates in effect prior to September 2025 to project the future average monthly discount will impact the calculation of the discount, will it not?
It will impact it, but it's not the sole determinant.
No. Now, turning your attention to PWD Hearing Exhibit 4. That's the response to PA TAP 4-4.
Yes.
In response to TAP 4-4, the department calculated the difference in the monthly total TAP discount for the period of January 2025 through August 2025 using base rates that became effective September 1, 2025. I assume you've reviewed that discovery response, correct?
I've reviewed it.
And do you accept, subject to check, that the difference in total TAP discounts comparing the period under current rates and prior rate period amounts to some $5 million?
No, this is where I have a problem, because if you look at the top of that, what was requested, we requested base rates. And essentially, when we got this response and I went through it, what was discovered is that what PWD provided was base rates plus the TAP surcharge. So essentially, you're not providing us with base rates for that period, for assuming that the rate increase were in effect.
During that period, we looked at typical bills and tried to compare that and to use a simplified approach to approximate what the difference would be with or without without the base rate effect, and trying to basically come up with an approach to seeing the impact of using lower base rates would have on the overall calculation. You're saying that you don't believe that there's a difference using lower base rates, or you're saying that you differ with us in terms of its calculation of PA TAP 4-4?
You asked me to confirm the amount. I think it's $5 million. Yes. And I can't confirm that because I disagree with the rates that you've used. And that was part of your objection earlier today when we attempted to request the information. But you said we were, if I recall correctly, we were trying to use PWD to put forth our position. And if you keep in mind, the fact is that we didn't have a chance for rebuttal. So when looking at the data and finding that there were some discrepancies, it is appropriate, I believe, to bring it up during this proceeding to try to rectify that. So I can't, the short answer is I can't confirm the number. I understand that without the rate increase reflected, the TAP discounts might be lower.
Okay, but would you accept, subject to check, I don't even know if you have to do that, new base rates will go into effect on September 1, 2026, correct?
That's correct.
And those rates will be higher than current base rates, am I right?
That's correct.
Now, as I understand it, well, let me ask you this way. Are you aware that Black and Veatch identifies several inconsistencies in your testimony in PWD Schedule 11?
Yes,
And you've corrected or revised your testimony to reflect some of those changes?
I reflected, yes.
Uh,
And I wouldn't say changed it. What occurred was there were some cell references that didn't get updated, and so the numbers turn out to not match what I claimed in testimony. So what I did was to go back and make sure that the cell references were correct. So to that extent, I changed it to reflect the correct cell references.
Most of the changes, as I understand it, that you shared with us yesterday relate to a table on page 6 of your testimony. Am I right?
Yes,
And on page 6, I see C factor, E factor, I factor, S factor are spelled out in the table, and the total amounts attributed to them in your recommendation. Am I right?
you're correct.
Okay. Now, you seem to change the C factor. Did anything else change? I'm just doing it by process of elimination here because I see those remain the same, whereas at the other lines, with some exception, pretty much constant. Do I have this right? In other words, you didn't change the E factor, did you, sir?
No, what I did was to reflect the appropriate tap discounts. And there were some other references off the top of my head, unless I go back to that schedule that I reflected. From what I understood from working with this model, the E factor was to capture the changes. So I didn't go in to change the E factor.
The E factor didn't change, the I factor didn't change either, did it?
No, those two didn't change.
Trying to look at the S factor, I don't know if that changed either. No, they look the same in both the black line and in your final product. So that didn't change either, did it, sir?
No, I think if you look at the red line, it's pretty clear what changed.
Do you have any other additional changes to make to your testimony?
Nothing that comes to mind right now, no.
Have you prepared work papers associated with the errata and revised testimony to explain your revised adjustments? Usually we have work papers that support, table changes, particularly fundamental to the filing. Did you provide
Yes, I
those?
do. I have those.
But you did not provide them as of today when we're cross-examining you and trying to judge the credibility of your submission.
I did not provide them. The main intent was that I reflect those items that Black and Veatch found to be incorrect. The work papers are not hidden. They're not. If PWD would like to see them, I have no problems providing them.
But as of today, I haven't seen them.
As of today, you haven't seen them.
Thank you. Okay. Now, would you accept, subject to check, that the numbers of participants shown on your table on page 10 of your testimony do not match or align with the numbers of TAP participants reported in PWD 5 or the updated version of the workbook provided on April 15th using production data? Will you accept that, subject to check?
Subject to check, yes.
And would you also agree that you've made all the changes that are shown in PWD Schedule 11, which is in the rebuttal testimony? Did you make all the changes that we recommended?
I attempted to make all the changes that, as I went through, that didn't flow through correctly. For example, the projected TAP billing loss and things of that nature.
Have not provided supporting detail as of today to show us the basis for your changes in the table on page 6 of your testimony. That, I think, is the most salient point for today.
So the option I had was to leave it with the numbers that Black and Veatch disagreed with, or to make a good faith effort to provide updated information. And I think what I'm getting from you is that the good faith effort was not good enough. For that, I apologize, but what we're trying to do here is to put on the table that Black and Veatch identified some discrepancies, and we made a good faith effort to rectify that.
Thank you, Mr. Morgan. That's all I have.
Mr. Haver? Oh. Is there someone virtual who has questions?
No cross for plug.
Good afternoon. Is this the first TAP reconciliation hearing that you've been involved in?
I'm sorry, could you repeat that?
Is this the first TAP reconciliation hearing that you've been involved in?
No, it's not.
How many have you been involved in?
Unfortunately, I haven't counted them, but from the first TAP reconciliation through this one, I've been involved in all.
And in this hearing, in your testimony, you're recommending an increase in the TAP-R surcharge. Is that correct?
Yes, it's correct, but it's lower than what the company is requesting.
Right, of course, that's what you're going to say. In all the other proceedings that you've participated in and provided expert testimony, is there any hearing where you have recommended against an increase in the TAP surcharge?
No, and the reason is because this is data-driven. It is a reconciliation process. And as I said earlier, it's virtually impossible to get the projections 100% correct.
We'll come back to that.
But may I finish my question? May I finish my response?
Right, but we'll come back to your explanation. I just asked a simple question.
Well,
So yes
yeah,
or
and
no
I
question.
was explaining. and
Yes or
then
no
cut-
question. Is there any case where you recommended against an increase? Yes or
I
no?
believe there was an actual decrease in the TAP-R 1 year.
I asked him
I'm not-
specifically.
And he
Excuse
may not
me.
recall because he wasn't
I'm
asked
not
this through the
asking you,
discovery
Mr.
process.
Ballinger. I'm not asking you. Sure. I'm not asking Mr. Ballinger. I asked that his testimony be stricken. I'm asking the witness specifically.
If you recall, Mr. Morgan,
We already have his response.
why are you still asking him?
I'm not asking him. You're just trying to introduce evidence to defend your undefendable position.
You're
I'm
asking about,
asking him again. I'm
Let's
going forward.
move on, please.
I agree.
Mr. Hicks?
Mr. Morgan, do you consider affordability of the TAP surcharge in making your recommendations for an increase?
As I said, no, as I said, this is a reconciliation process and there is no factor in there for affordability.
Do you consider public input in your recommendations for increasing the TAP surcharge?
I was not at the public input, but I think the public input is important because the board is aware of customer sentiments and that can be brought into their decision making.
Right. I asked specifically, sir, about do you consider public input in making your recommendations? Not asking you to judge what the board does or doesn't do. I'm asking you specifically, do you consider that in making your recommendations?
I apologize, Mr. Haver. I thought I answered it. I did not include a factor for public feedback.
The surcharge on people's water bills, how is that different than a sales tax?
We've objected to this identical question posed through discovery, and we provided an explanation in addition to the objection. And that was not provided by Mr. Morgan. That was provided by the public advocate, and it's on the record already. But I will maintain our objection to this question.
Objection is sustained.
You don't even let me finish. This just
asked.
shows how unfair you are. You don't even give me a chance to explain why it's germane.
Being very inconsiderate, Mr. Haber.
Again, I don't expect anything other than you to defend the hearing examiner and the water rate board because you support raising rates every time. That's what you do. You're here to support
carry
them.
on.
You're not
Ask
here
your
to
question.
support.
Ask your question.
I have asked the question. You
You've
have made a
I've
comment
objected.
on my behavior, and I object.
You
to
are
that.
being very rude.
I object to you participating, defending them.
There's a way to do this
supposed to be
professionally.
Representing the ratepayers, not representing them, although that's who does pay you. And that should be very clear by your behavior. Again, the specific reason is to address the issue of where else could the money come from. So I'm asking specifically, what's the difference between a surcharge and a sales tax?
Which is beyond the scope of this proceeding.
How do you come to that conclusion? Isn't this
This is
proceeding
a
about how much?
reconciliation.
Isn't this proceeding about how much more you're going to charge people?
Given the framework that we have to work with,
Isn't this proceeding about how much more you're going to charge people?
given within the framework that we have.
Yes or no? Is that what we're discussing?
We
How
are
much more you're going to charge people?
The formula is set. We are limited in what we can do in this particular proceeding. In a general rate increase, more issues can come to the table.
Are we discussing how much more people are going to have to pay?
Yes,
Okay. So I'm asking a specific question. How is a surcharge on a basic necessity of life different than a sales tax on a basic necessity of life?
Maintain our objection.
Oh, I apologize if Mr. Hicks is speaking. We can't hear him on the Zoom.
Thank you. I was just jumping in to say that. The last thing that I have on the record is Mr. Haver asking, how is the surcharge on a basic necessity of life different than a sales tax on the basic necessity of life? And then I have Robert Ballinger's objection, and that is the last thing that has been on the record.
That microphone's not working.
We still cannot hear. I'm going off the record right now.
The mic wasn't on previously, folks, apparently. Narrowly, 2 points. It is
Okay.
inappropriate for the hearing officer to be cross-examined in these proceedings, and Mr. Haver should be admonished for doing so. The second point is in this instance where discovery has been propounded, objections have been provided, and no motion to compel was provided as required by the rules of civil procedure, those questions can no longer be explored.
You ready to move on?
I'm waiting for a decision. Are you going
Question
to, are
is-
you going to get them to answer how is a surcharge on a basic necessity different than a sales tax on a basic necessity? Are you going to force them to answer?
I will not.
Thank you. Mr. Morgan, did you look at the possibility of the city's operating budget funding the TAP program?
I believe we had an objection on this as well. I believe there was a question about, in the discovery about grants or something related. Is the water department able to accept grants from governments and or foundations, to which we objected, while also, again, endeavoring to provide some responsive information, which includes the fact that the city finance director takes the position that all operating expenses have to come from project revenues of the water department, which I believe is directly responsive. But again, we are objecting to this. This is way beyond the scope of Mr. Morgan's testimony and the subject matter of this proceeding.
I'm simply asking, did he consider it? So yes or no? It's not a
You
surprise.
can ask whether he considered it.
That's what I asked. Did you consider funding the TAP program from the city's operating budget like we fund the low-income SEPTA riders program?
Mr. Morgan, you can respond to that. It's a yes or no question.
No, it's not part of the formula.
Thank you. I'm finished.
Is there any redirect?
No redirect, Your Honor.
If Your Honor, please, we had a question that was pending. Andre Jasson for PWD. We had a question was pending concerning the transcript requests of the public advocate.
Right.
I reached out to the consultants, and Black and Veatch and Reftelis indicated that responding to TR1 within the normal timeline for a transcript response, which would be like 3 days, would be very burdensome. It would take them about a week to answer if you wanted to get the correct answer, because you have to go back to billing data. And they want to, make the response as comprehensive as possible. But that would be our timeline if you wanted to pursue this, and taking into account input from the consultants who would actually be doing, and Reftelis would be doing the lion's share of this. Recognize also that this is also during the period where they're assisting me with the brief and trying to get everything done to sort of complete a record, and if possible, even explore settlement. So we are just suggesting that within the timeline of a normal transcript response, it is burdensome. We've given you a timeline that we think would work, which would be something like a week, and we'll leave it there.
And briefs would be due in a week.
We're always playing catch up in these proceedings, Your Honor. We've had to to have objections and motion practice to get information in this proceeding in time to even look at it. And it really is, it's hard to believe this is that challenging. As I said, the volumetric data is already in the model. We know what the TAPR surcharge is that applies to the usage. It is really just a matter of multiplying the volumes by surcharge. I don't believe there's any more to it than that. So I don't personally believe the explanation that's been provided here today. That said, if we can't have it in time for the brief, then I might as well just, the data is not of any use to us if we can't have it in time for the brief.
That is the time frame. That is the time
Yes,
frame.
that is the time frame.
Then I think we'll just withdraw the transcript request at this time.
Okay, well, for the rest of the transcript responses, they are due May 18th. And we've got a brief or settlement petition due on the 22nd. Objections to any settlement petition, and if there is none, if you would like to file a reply brief, that would be due on May 26th.
So,
Excuse me?
Yeah. Cited utterance.
I'm sorry, can you go over those dates again?
Sure. And they're in the pre-hearing conference order. The transcript responses are due on the 18th. Brief or settlement petition is due Friday, the 22nd. Any objections to settlement petition? Or if there is no settlement petition, if you'd like to file a reply brief, that would be due on, excuse me, Thursday, the 26th of May.
I have Tuesday, the 26th. Did I mishear
That
you,
Tuesday?
Your Honor? Yes, Tuesday, the
Tuesday,
26th.
sorry. And then my report will come out on June 10th. Exceptions to that will be due on June 15th. I believe that's a Monday. And then the board will take it up on the 24th of June with a final determination on July 1st. I ask you to please, if you're filing briefs, settlements, objections, to file them in PDF and also send a copy to me in Word. That would be helpful in capturing your quotes exactly. And with that, is there anything else we need to address before we adjourn?
Tomorrow, we have tomorrow reserved, but I think we do not need it. So I think we can cancel.
Yes, we can cancel
If Your
tomorrow.
Honor agrees.
Nothing further. Thank you.
Nothing further from us. Thanks.
All right, then we are adjourned. Thank you for coming.